All right. Good morning, everyone. Firstly, thank you so much for joining us today. My name is Monique Culbert, and I am joined by my colleague, Justin Hattingh. And today we'll be exploring the legal landscape regarding retirement and how basically employers can manage the retirement process in a fair, transparent, and legally compliant manner. Okay, so on the agenda for today, we will be discussing a wide range of important topics that one should understand when managing retirement in the workplace. So the agenda includes the key legal framework, which includes the Basic Conditions of Employment Act, Labor Relations Act, and Employee Equity Act, Employment Equity Act, my apologies. Okay. Thereafter, we'll be going through the legal concepts, including what is meant by an agreed retirement age versus what is a normal retirement age. We'll then be looking at what common challenges we have found that employers are facing today when it comes to retirement. Thereafter, a few landmark cases that gives us a little bit of guidance. We'll also be looking at best practices to follow, so it gives a nice practical guideline on how to deal with retirement in your company. Thereafter, critical questions that we all obviously have on our minds when looking at retirements. We'll do a little bit of a Q&A and then provide some takeaways for today. Okay, then let's get started. First thing we're looking at is our legal framework. So it's very important to note that South African legal framework for retirement does not actually prescribe a fixed or mandatory retirement age. The Labor Relations Act, specifically Section 187 1F, states that a dismissal on the grounds of age is considered automatically unfair unless an exception applies. So that exception is detailed in Section 187 2B, which states that a dismissal based on age will not be automatically unfair if the employee has reached the normal or agreed retirement age for persons in that position. Furthermore, the Employment Equity Act prohibits unfair discrimination on several grounds. This includes age, which further reinforces the importance of obviously following a fair and legally sound retirement process. Okay. Let's look at agreed versus normal retirement age. So in our employment law, agreed retirement age would refer to a specific age that has been formally documented and mutually accepted by the employer and the employee. Typically, this would be in your employment contract or incorporated in your workplace policies. This agreed age provides legal certainty and is obviously enforceable at that age. Further to that, we have a normal retirement age. This arises when a specific age, which is not agreed upon, but is instead established through workplace practices, industry norms, basically within the industry that one is assessing, and also includes long-standing customs of when an employee in that specific industry is usually retired. So when this is the case, courts then consider obviously what is determined in that industry to qualify as a normal retirement age. We obviously also have some common pitfalls that we face when retirement becomes an issue within a company. These could obviously have some serious legal consequences, especially when one then faces an automatic unfair dismissal. So common pitfalls that we have found arise are that of when there's no retirement clause. So this is obviously where there's failure to include a retirement age either in the employment contract or in policies that are established within the company. So therefore, without a clear agreement, it's quite difficult then to enforce an age where you enforce a time to retire an employee. We then look at unverified industry norms. So as I previously said, when we look at a normal retirement age, it's decided through industry norms, and a company faces legal risk when it hasn't really delved into what is the industry norm by providing supporting documentation or a consistent pattern in the workplace for what is a normal retirement age. Another big challenge faced is informal extensions of post-retirement age, which means where employees are allowed to continue working past the agreed or expected retirement age without formalizing the extension. This obviously can then create an implied new contractual term and then creates risk when you do want to dismiss that employee based on their age. Another thing we'll be looking at is, or rather another challenge we face is where a unilateral change is made, where there is an agreed retirement age, but the employer, without the consent of the employee, has now gone and changed that age. Then in these situations, when companies attempt to then use retirement as a pretext after retirement age is reached, rather than following procedures such as retrenchment or a misconduct procedure where this is relevant. So that could also create legal challenges for a company. We have some important case law here. These are some landmark cases that we have in South Africa. So we have firstly here Herbert, the Herbert case. In this case, there was no agreed retirement age. And as a result of this, when the company decided to dismiss the employee based on retirement, it was then found to be automatically unfair because of the basis that it was discrimination on the basis of age. We then look at BMW vs. Depp. BMW vs. Depp, an employer had, in this case, unilaterally changed the retirement age from 65 to 60. This was then challenged by the employee because there was no consent from the employee's side or no agreement from the employee's side. This was also held to be automatically unfair. The Walker case was hugely relied on in the past. In this case, the employee had reached past retirement age, continued to work for approximately 5 more years, and thereafter the employee was dismissed based on retirement age. This was at that stage held to be fair, but we found since then that the Constitutional Court has decided or has had various different interpretations as to when or how long one can keep an employee after they've reached retirement age. So 2 very important cases is our Landman case and Strydom. Strydom is the one I first want to just have a look at. Strydom basically states that this was a few employees where they had continued to work. Strydom specifically had reached 60 but continued to work and was thereafter dismissed. However, when he was dismissed, he basically concluded that the company in itself had created an expectation that employees are working till 67. So these employees, through practice, or this company rather through practice, had been dismissing employees at the age of 67, and Strydom challenged this, and thereafter it was found to be an unfair dismissal because of the fact that he has not yet reached 67. So then obviously it means that it's very important that where there is an industry norm, that this is looked at and discussed, and that you don't create an expectation for an employee to work to the normal age rather than what the agreed age is. Landman, this was a very split decision by the Constitutional Court. The Constitutional Court basically was split almost down the middle. What happened in the Landman case was that the employee had worked 10 more months after he had reached 60 and was thereafter retired. Some of the judges ruled that an employee can at any time be retired after they reach that age, but also there has been huge controversy because it then puts the employee at a very risky position where they can then, after reaching the agreed age, be dismissed based on age for any particular reason, as I had said, instead of following the right procedure for retrenchment, example, or misconduct. So we are still in a position where the Constitutional Court has not yet quite made up its mind in terms of what exactly the processes are. But what is very important is that we have created certain protocols where we believe that this is the best way forward in terms of addressing retirement and what to do in the certain cases where you find yourself in a position where you need to retire an employee. Okay, I will now hand over to my colleague Justin to continue with what should be in place.
Thank you, Monique. So everyone, as you can see, our main watchword here when it comes to retirements is extreme caution, given the legal uncertainty that has arisen as a result of Landman. Now, what's very important is to always make sure, where possible, that there is an agreed retirement age in all contracts, because as my colleague Monique referred to earlier, sometimes relying on industry norms puts you at risk, especially if, as she said, they are vague, there isn't a uniform established custom and the like. Now, what we suggest then is that you need to have a look at your contracts and then make sure that they are clear in terms of what the agreed retirement age is, and then also align your policies as well with any pension or provident fund that you might have. So for instance, if you have a contract or a policy that says 65 and your provident or pension fund says 63, rather than align it with that provident fund. Now, the other thing that we need to also make sure of is that when we are implementing or amending a policy, it must be communicated and employees must be given a fair opportunity to ask questions, to gain clarity, and thereafter then also be given an opportunity then to raise concerns. Ultimately, they need to have a reasonable time then within which to familiarize themselves and ready themselves in terms of that. Also, what happens is sometimes there might be certain positions which would then have a different retirement age to the rest of the company. So for instance, if you work in the motor industry, it's very likely that someone working in the workshop or the warehouse would retire earlier than someone working within the admin department. And that's why you need to make sure that it is clear and consistent. Now, what's also important is if you do intend to use someone post-retirement age, as indicated before, because of the legal uncertainty, rather don't just allow them to proceed afterwards. What you would do is you could use a fixed term contract in order to then create some certainty for everyone and then ensure that there isn't any dispute after the person leaves your employment. So in other words, one of the best reasons why you could use a fixed term contract post-retirement is then to ensure that there is proper succession planning within your workplace, that new people coming up through the ranks are trained, and that they are capacitated for their roles. Thank you, Monique. Then we can go to the next slide. Now, in terms of best practices for employees, as indicated, what you need to do is go back and review all your policies and your contracts for a retirement clause. Now, if there isn't any retirement clause, what you would then need to do, if you intend to impose one, is to once again consult with employees and then gain their consent. What is very important to note is that when it comes to retirement age, in South Africa, the real retirement age, according to economists, is actually 73, given economic pressures and the economy not being at its best at this time. So people would be very reluctant to agree to that. So I can't reiterate this enough. Consultation is the name of the game. Also, as indicated before, if an employee is about to reach their retirement age, it's not a matter of just allowing them to then carry on and then proceed. You need to notify well in advance. Also, it's not a matter of calling them in on the day that they turn 65 and saying, thank you for coming. Best practice here would be to remind an employee of the contents of your policy and your contract of employment, possibly a month before, so that they can start preparing themselves and putting things in place. Also, once again, If someone is going to work past retirement age, we also recommend that you place that in writing in terms of a fixed term contract or agreement. Ultimately, you need to say to them, well, look, you have reached retirement age, but we still need your skill and your experience to capacitate younger workers so that they are then put in a proper position should you leave and that it doesn't affect operations. Also, very important, please avoid unilateral changes. Do not just impose a new retirement age, as this would be a unilateral change to terms and conditions, which would then expose you to, amongst other things, a dispute at the CCMA. And once again, I reiterate, it's important to align HR policy with your particular pension or provident fund rules. Thank you, Monique. So in terms of critical questions, it says there, can I force retirement at 65? And the simple answer is no. Even though the Constitutional Court has muddied the waters somewhat, where it's 4 judges have said, well, if someone has reached retirement age and they've worked past that, you can enforce retirement at any age. I still reiterate caution. Best practice here is to consult with someone, indicate to them that they have reached retirement age, they've gone past it, and ultimately they need to then start making room for new up-and-comers. It's always important to make sure that you get that agreement. Now, the next question here is, what if we never agreed on an age? Once again, consultation is key. What you would do is you would call this employee in, you would explain to them, look, they are reaching an age where normally they would need to retire. Maybe it might be 60, maybe it might be 65, and find out what their plans are, and then try and reach an agreement. Also, this would need to be tested, but if there is no agreed retirement age or even a normal retirement age for that matter, possibly one option would be to discuss with the employee the fact that usually in terms of SASSA, all citizens are eligible for an old age pension fund or old age grants once they've reached the age of 60. Maybe this could be a point from which you can depart and then discuss the possibility of retirement. And then ultimately, critical questions here. The last one is, can I let someone stay on post-retirement? Absolutely, yes, you can. But as indicated previously, what you would need to do is have a legitimate reason for that, such as your succession planning, after which you would then formalize that agreement and then place it on a fixed term contract, possibly for another 6 months or for however long you might need them. Thanks, Monique. Okay, so as you can see here, key takeaways, and I'll once again reiterate this given the legal uncertainty, is you need to make sure you practice extreme caution, especially when there is no agreed retirement age. As you've seen, it carries substantial legal risk for yourself as an employer, given that it might be found to be automatically unfair and discriminatory based on age. Ultimately, that could expose you to, amongst other things, an award from the Labour Court, which amounts to 24 months of compensation, possibly even reinstatement, and then damages in terms of the Employment Equity Act. Also, very, very important, as we said, if you do not have an agreed retirement age and you have a practice, please make sure you document those retirement ages up front, communicate it to employees, reduce it to writing in your contracts, in your policies, and also make sure that you align it with your provident or pension fund. Also, as anything in labor law, especially when it comes to dismissal, you need to have a proper reason and then also follow a fair process. And that includes allowing the other party to make their submissions, you considering those submissions, and then giving your final determination. And also important, even if there is an agreed retirement age, make sure you consult with that employee, bring to their attention the retirement age, bring to their attention when they will be retiring, when their last day would be, and give them proper notice. Also, it's very, very important, even though there is that split decision, as said before, it seems to be that the Constitutional Court is leaning more towards safety and making sure that people aren't just retired with no proper reason or no proper consultation post-retirement age. And finally, always act fairly, play open cards with your employees, and make sure they're given an opportunity to make their submissions, raise their concerns, consider those concerns, and give a proper response thereto. Thank you, everyone. So now that brings us to the Q&A session, and then I will open the floor at this stage. As you can see, everyone, what you can do is then type your questions, and then we will then answer those as we go along.
Looks like we must have done a good job explaining.
I certainly hope so.
See, we've got a hand up, Louisa. I'm not sure if that is, oh, there another one, Vera Pretorius.
Good afternoon, this is Vera speaking. Good morning, rather. I just want to find out how legal is it? You said now that the economists reckon the retirement age is currently 73. But if we do not have a retirement policy, but how legal is it to say, okay, your retirement age is say whatever, 70, whatever, as long as you are fit and able? And what is the process if we want to then terminate before retirement age as stated in the policy? Would that be a capacity inquiry then, or how does it work?
Yeah, so ultimately, if someone hasn't reached retirement age, you would then need to explore other alternatives, and there needs to be a proper basis for it. So if you do intend to go the incapacity route due to performance, you would need to show that they aren't performing according to requirements, that you have gone through a process of counseling, that you've given an opportunity to improve, and then ultimately there hasn't been improvement. But ultimately, when it comes to terminating someone before retirement, you would then need to get their agreements, especially if there's a policy in place.
Okay, thank you.
Sure. Okay, let me just see here. So there's a question here from Sharon Postuma. Do we have to offer the same benefits after official retirement age? So ultimately, if someone has reached retirement age and you have then terminated their employment but offered them a fixed term contract thereafter, that would be seen as new employment, and you would then change those terms and conditions. If you allow them to continue after employment, or sorry, retirement age, and there hasn't been that discussion, there hasn't been any determination, I would then think you would have to then adhere to the contractual terms. Any other questions? Louisa?
Hi, can you hear me?
Yes, I can, thank you.
Okay. A question for you. We're all pretty old. We're older in the company. We're as a section of us who are oldies, as I say. Where we have a particular individual, if we feel that individual she's perfectly able, quite frankly, but if we feel that she needs assistance, so I'm trying to do this politely, if she's needing assistance, we would need to bring somebody else on board to assist her in her position. Would we then be able to then say to her, you can do less hours, and then that would mean that your salary is reduced? I'm trying to subtly say that actually her time maybe for retiring is coming very close, and it's a very delicate situation.
And then in this situation, you don't have any agreed retirement age or normal retirement
No,
age?
we do. Weirdly enough, we do. Our age is 60, but we took her on after she had actually retired from her previous position. So we took her on knowingly she was past our normal standard retirement age. And so her age is actually 72 now. And she, as I said, she's perfectly fit and able. But my view is that because you have to be considerate as well, my view is that it is only fair that, and obviously I would then be speaking on her behalf, it is only fair that she should be doing less hours and having an assistant, because I know myself that my brain isn't as energetic as it used to be when I was much younger. And I just, because it's a very delicate matter, could you legally actually then introduce an assistant and say, look, we wish to bring an assistant so you can then train, and the purpose is to actually take over your position. Well, we'll have to take many, many years to be experienced as she is. But then we would reduce your time in the company and the hours. I can't see it working anyway, to be honest. So this is very much of a hypothetical question, but it's a question that goes around and has been spoken about. And what is your view on that?
So ultimately, once again, I think this comes down to, as you said, treating it delicately, practicing extreme caution, and it really needs to be as a result of consultation with the employee. Explain to her, well, look, you know, as much as you are capable and you are able to perform these duties, we do feel that you would benefit from having an assistant. But what that comes with is, with the reduced workload, there would also be reduced hours, and then you would reduce remuneration. You know, try and consult with her, get her views, get her inputs, and then ultimately come to some sort of agreement whereby she says, okay, well, I now agree, this is the way forward, and ultimately you would then sign an addendum to that contract of employment and then implement those required changes. I hope that answers your question, Louisa.
Yes, I mean, I knew that answer anyway. It's just, I think it's such a delicate, it is such a delicate situation, because quite frankly, I know that she will say, I can do the job myself. She, because she can, but it's also, I see sometimes, and not very often, but I do see slip ups. So I'm also always having to make sure that it's 100% okay, always her work. And I have to do that because she's human, and I know that I have to always watch what she's doing.
So the other thing that could possibly come into play here is, as you said, she is slipping up. What you could do is go through that performance counseling process and then offer this as an alternative, you know, to a full-blown inquiry eventually, whereby there's a termination. So you say, well, look, there are these performance issues. What we're willing to do is provide you with this assistance as an alternative,
Yeah,
and then
that's
hopefully
probably
get
a
some
good
form
idea.
of agreement there.
Yeah, I think that's probably a better way of doing it, because it's actually been introduced because of facts. It's not just a hearsay. It is because of facts. Okay, thank you very much. I think it's I think the subject that you've introduced is a very delicate topic, especially with people that have become older than 60. So thank you for sharing your knowledge.
Oh, my absolute pleasure. Okay, then I'm going to look here in the chat. So let's see here. So from Siabulela, hi Justin, thank you for your presentation. What can an employer do in the event that they do not have a retirement age policy or contracts of employment that explicitly state the retirement age? Upon consulting with your employees with purpose of introducing a retirement policy and updating the contracts, there's a split of opinion in terms of the retirement age. Say, for example, half your employees prefer the retirement age of 60, and the other half prefer 65. what does one do in that case? Is one has to tread carefully. Can the employer enforce a retirement age, even if the employee does not consent to it during consultation? Okay. So ultimately, what this would come down to is, if there is going to be a policy introduced within your workplace, as indicated before, it's best to obviously have that consultation process with all employees involved. You can explain to them the reason for wanting to implement that policy, how you foresee it playing out, the time that it will take for same to be implemented, and ultimately get their views, get their concerns, and maybe find a middle ground in terms of this particular issue. So if others want to say 60, others say 65, maybe you could do a 62, 63, and possibly get some form of consensus in that word. But ultimately, enforcing a retirement age, especially where there isn't any contractual employment agreements, would be a bit of a problem. So key question here, as I said before, is caution and consultation. Ensure you get that consent. Okay. Right, thank you very much. Any other questions? Vera?
What if you cannot reach consensus if you consult with the employees? What if they do not want to accept the retirement age? Can you then say, listen, but this is now the new company policy? Can you then enforce it?
So that's a very, very loaded question. And ultimately, when it comes to policies and procedures of a company, those are usually at the discretion and prerogative of an employer. And ultimately, you need to play it by ear and see, okay, well, once again, let's look at our particular industry. If you've got that provident fund or pension fund, try and then align a policy with that and give people time to acclimatize themselves to it and then ultimately get used to it. But if there is no agreement between the parties, it's a very difficult situation you find yourself in. As I said, first prize is to make sure there's always certainty. But as I said, implementation of a policy is at the discretion of the employer. And I would just obviously consult as much as possible, as far as possible, make sure everyone's had an opportunity to be heard, and then slowly implement that policy. And hopefully over time, then people will accept it and become comfortable with it. Any other questions?
I don't see any more questions from my side.
Sure. Okay, well then, thank you very much, everyone, for the opportunity. I hope you had a eye-opening experience today and that you have been given the tools to deal with retirement going forward. Ultimately, the best thing to do here in these circumstances is don't try and do it by yourself. Always reach out to someone that knows what's going on, especially labor specialists like ourselves. And as you see there, you're always welcome to contact us for any assistance that you might have.
Thank you, Justin. Thank you, everyone, so much for joining us today. We really appreciate your attendance. And again, please contact us for any assistance you may require.
Thank you very much, everyone.
Thank you.